Hello everybody, again this is Charles Rather, Managing Attorney at AmLaw Group. Today I wanted to talk a little bit about the difference between non-immigrant visas and non-immigrant visas that are dual intent visas. So we're talking again here about all the whole case of non-immigrant visas, but some allow you to have immigrant intent and some don't. And in some cases that can really be to our client's advantage or disadvantage depending on what situation they're in. So for example, what are we talking about? Non-immigrant visas, the most common ones we deal with are L1s, E2s, H1Bs, O1s, and F1s for students. The F1s are for students. Out of those, two of them allow you to have immigrant intent, namely L1 and H1B. So what that means is even though these are non-immigrant visas, just like all the other ones, the E2s, the O1s, and the F1s, if an officer at the consulate suspects that you have immigrant intent, but you're applying for an L1 or H1B, that can't be a basis for a denial of the visa. So if they think, deep down you're thinking of maybe immigrating, getting a green card in a couple of years, which a lot of our clients are, to be quite honest, even if the officer has evidence of that or even suspects that, for those two visa categories, that can't be the basis for a denial. And so sometimes that's important, very important for our clients based on their particular circumstances or if they've had previous denials. For example, sometimes we've had cases where a client went to a consulate for an E2 and he got a denial. And the reason for the denial was they suspected he had immigrant intent, that he was planning to move permanently to the US. That can be a disqualifying factor for an E2, but it can't be for an L1. So what we did with the client is we were able to rehab his case, convert it into an L1. Now, I'll readily admit that's not always possible because people who qualify for an E2, their situation, their work experience, and the affiliation between the overseas company and the US company might not be such that it allows to file for an L1. But assuming we can get around those issues and we're able to meet all the requirements for the L1, that could be a good solution for you. That if you have a denial, and it doesn't have to be an E2, maybe you have a denial for some other non-immigrant visa, O1, maybe even F1. That's not the end of the world for you, right? If you've got a denial for one of these categories, and if the reason for the denial was they suspected you having immigrant intent, you're still generally readily able and have access to L1s or H1Bs, for example, that would allow you to come to the US, even if they think you have immigrant intent. So please keep this and other things in mind when working with your attorney to come up with an effective strategy. Because in cases where clients have had denials at the embassy because of suspected immigrant intent, or maybe they're undergoing administrative processing and it's taking forever to get that finished, and the reason for the administrative processing is suspected immigrant intent, it might make sense to look at other visa options that allow you to have immigrant intent. And we've done that recently as well with another client who was waiting almost a year to hear back on his EB-5 visa at the embassy. And we went ahead and he filed for the H-1B. He won the lottery. And he's going to come down to the US on the H-1B. And then once he gets here, we will adjust his status to a green card based on the approved EB-5 that he has. So the embassy was taking forever to issue his immigrant visa for the EB-5, and we just kind of did an end run around them, got the H-1B, which allows you to have immigrant intent, and allowed him to get here. So please contact us if you have any issues or circumstances similar to what we discussed today, and we'd be happy to help you out. Take care.